Hey, thanks for making it to Veterans Daily with Jay and Clay. We are glad you made it. We have some important news to share with you. We want to talk it through because, look, everybody gets the bumper sticker kind of version of things, and then you're up to your own devices to kind of figure it out. We're going to dig into it a little bit to understand exactly what's going on, what sort of implications there could be, or positive collateral effects. Kind of could go either way, and we want to just share with you so you're prepared and we can eliminate some of those I wish I would have known. Hit the thumbs up, subscribe, share with a friend is what my rooster Stan is saying. So please do that if you haven't. And like always, Clay picks the topic 99% of the time. So if you don't like it, you know who to blame. All right, Clay, lead us into it, and we'll get going here.
Yeah, so today we're talking about the Supreme Court Bufkin v. McDonough and what all that entails. And then we're going to switch shifts into why evidence matters and then go into the appeal process, because the Supreme Court decision, or the case at the Supreme Court, is essentially the benefit of the doubt, meaning 50-50. I'm a big fan of veterans being over that 50% mark and not even have to deal with the benefit of the doubt. So you're not relying on someone else to make that decision for you. Submit those evidence-based claims up front. And so Supreme Court, why evidence matters, and then the appeal process, specifically using evidence with the appeal process. Jason, I'm going to kick it over to you because this is actually your wheelhouse when it comes to policy. You cover policy better than anyone else here on the YouTube.
Not true. I think it's you. All right, but go ahead.
Give us a recap of the Bufkin.
So first, I want to echo what you said, Clay. Yes, I am. No, I'm just kidding. The part where you said that you are a fan of supplying more evidence, right? And I just think I want people to understand that, and I'm sure you've been guilty of it. I've probably been guilty of it, you just need to meet that threshold of equality, right, in evidence somewhere. Now, a lot of times I'm saying, hey, look, ask for a nexus letter that says more than likely. You'd prefer that, but you can back down to at least as likely. And so when people are hearing these words, at least as likely, the whole reason you're hearing any of us on YouTube say at least as likely, or if you buy a t-shirt from Clay that says at least as likely, right, you are going to now understand why we're always talking about that. And it's because there is actually rules in place for the VA to follow. Do they get it right? No, they don't always get it right, but sometimes they do. And look, I would argue that more times than not, the VA probably gets it right, but there's a big chunk. And when you're talking about millions of claims, a small percentage is tens of thousands of people. So, they're not going to get it right all the time. That's why the appeal process is in place, both internally and externally from the VA. And so the way that it works, and I'm just going to walk you through it real quick. You file a claim with, I filed enough evidence. I feel good with, I'm not going overkill. I don't have enough time to, really double down on everything. That's enough for them to decide. And you feel okay about it, because you haven't watched Clay on the CivDiv saying evidence-based and just, make sure it's all there before you file it. It's very important that you put the work in up front. But let's just say that you put in enough. So you do that. The VA comes back with an unfavorable decision. We prefer here to say unfavorable because denied infers that, well, you are not service-connected. Well, you could be service-connected, but you could have a lower rating, right? So unfavorable decision. Now you have options. You can do higher level review. You could do a supplemental claim. You could push it to the Board of Veterans Appeals. At the Board of Veterans Appeals, it's seen by a law judge. Well, they could kick it back. They have three options. They could remand it, send it back to the VA for additional information. They could deny it, which sucks because you've already had unfavorable decisions up till then, or they could approve it. Well, let's say that they deny it. If they deny it, that's an unfavorable decision. You now have another recourse. Actually, a lot of people out there don't realize there is another court that you can send it to, and it is the U.S. Court of Veterans Appeals. So inside of our process of veterans claims, we have kind of like a lower court and a higher court. You have BVA, the Board of Veterans Appeals, and then you have the U.S. Court of Veterans Appeals.
Mhm.
And what the argument here is that the higher court, the U.S. Court of Veterans Appeals, has not been reviewing disputed claims with the glass, with the eyeglass of, did all the other entities look at the benefit of the doubt rule? They have simply just been looking at the raw evidence and and the decision, and did they mess up? Oh, okay, they decided not to. Okay, well, that's fine. It looks like they checked all their boxes. Everything is the way it should be, and they weren't really investigating, if you will, whether or not the evidence was actually in equipoise. Okay, equipoise is equal on both sides. And guess what? One of the things that we learn through this process that's going with the Supreme Court, Clay, is that it's not even really equal. It's close to equal.
Yeah.
It's not even like it has to be exactly, 50 stones on this side and 50 stones on that side. No, it could be 51 and 49. And they're like, no, I mean, I don't really know. I'm not really I got all this stuff in. It's kind of close. I don't really know. So there's actually even a little gray window within the 50-50. So this is where we're at. And I'm not going to jump into what my kind of mindset is on what's going to happen. I want to kick it to you, let you fill in any of the gaps, give your overview on kind of where we're at and why we're here. And then we can kind of jump into what we foresee.
Yeah, so there's kind of two separate conversations, right? You have the veterans' cases individually. So I believe Bufkin was denied, meaning not service connected, and the other person, I totally forgot his name, starts with a J. He was service connected to a 50% for mental health, and he's arguing for a 70%. Both of them have some kind of evidence, and that's the question that I want answered personally. What
Right.
is that evidence that says
Yeah.
they should be service connected and that says
Right.
they should be at 70%? So that's the individual level. That's the individual conversation about their benefits. There's a other conversation about U.S. code and law, and that's what we see really at the Supreme Court, right? These veterans, and this is going to sound really bad, but it almost seems like it's a stepping stone to argue the benefit of the doubt for the lower courts, right? At least that's how my mind sees this.
Right.
Because if you look at the argument recap, it's really not referencing the veterans individually at all. It's just saying, hey, holistically, the VA, I'm saying that generally, the VA is supposed to look at the benefit of the doubt rule, and they're not. And that's what's being argued in the Supreme Court. And I want to show everyone, because we always talk about the benefit of the doubt. I'm just going to read it real quick. It is code B here. So code 5107 from Title 38. It says the secretary shall consider all information in lay and medical evidence of record in a case before the secretary with respect to benefits under laws administered by the secretary. Here's the important sentence here. When there's an approximate balance of positive and negative evidence regarding any issue material to the determination of a matter, the secretary shall give the benefit of the doubt. Okay, shall give the benefit of the doubt. That's the argument at the Supreme Court. And the reason I want to separate those conversations is because 100% I'm on board with this benefit of the doubt, for sure. When you look at the veteran who's going for the increase from 50% to 70%, I think it's mental health. We just talked about how ambiguous the rating scale for mental health is. And, you'll see language in your decision letter when you thought you had 70, but then you're awarded 50, it'll say something, although you
Right.
have symptoms at 70% mark, you closely associate with 50%. It's like, what?
Right.
What does that even mean? That almost seems like another way to say the benefit of the doubt for me. Those
Right.
two I'm on board with. Jason, I am going to throw a curveball in here, and I hope this is received well to the audience, because of the digging I could do on Bufkin and his situation. I don't see the evidence, and that's the key factor that I want to see personally. But I am gonna
I'm
say,
glad you're bringing this up. I'm glad
Yeah,
you are, because I wanted to talk about this too.
I am going to say something, and I hope it's received well. But here's what I know right now. We have a gentleman who served 6 months in the Air Force. Something happened in his wife's life. His family death, maybe a child died. I mean, it could be. We have no idea,
Oh,
right?
all
Or I know.
speculation at this point. Yeah.
Yeah.
All you know
I
is the end result.
Yes. And so she, for lack of a better term, goes crazy and has a mental health breakdown to a point that allows this Air Force active duty airman to leave the service on a hardship discharge. That's not common. I only know one person on a hardship discharge. It's because his wife was terminally ill. He got out of the Marine Corps. His wife died. It's a super sad story. And that's like the level of discharge, right? So we know that it's serious, right? It's serious enough to do a hardship discharge. Well, this airman decides to do a claim for post-traumatic stress disorder, is denied, and then there's two parts to this. One, he's denied, and two, in an article, I think it was from military.com, an article had mentioned that the PTSD diagnosis was not in line with the VA standard for post-traumatic stress disorder. So that's what we know.
Right.
And all I'm saying is, I think the stepping stone to the Supreme
Right.
Court really matters for that veteran specifically. But there's a lot we don't know too. So
Yeah.
don't
Yeah.
shoot me yet.
Right. Right. And here's my kind of take on it, and I already know how we, the veteran community, can be even against ourselves, right? We are sometimes the hardest critics on ourselves, but don't let anybody else say anything about any one of us, right? That whole thing. So I had this feeling when I was going through it that there could be a little additional focus, if you will, on that service member's situation. And you're like, wow, come on, man, you don't deserve that anyway. Take that aside. Who cares, right? Who cares if he does or if he doesn't? Like you said, we don't know the evidence. Apparently, there's enough to take it to the Supreme Court and the Supreme Court to actually hear it. Because guess what? The Supreme Court says no way more than they say yes to
Yeah.
hearing a case. So there has to be some sort of merit to his claim, whether we, the general population of veterans, agree or not, based on extremely limited information. It doesn't really matter. So don't get wrapped around the axle on the stories that took us here, but rather the reason why we're here, which is the benefit of the doubt rule was not taken into consideration and essentially skipped over at the highest levels. And I think that what happens is that the argument from the VA from their attorney is essentially, this shouldn't be like the court shouldn't have to bother themselves with, they would have to, it's extra work and all this stuff and blah blah blah. And I'm thinking to myself, well, when does it get checked? If the VA screws it up front and they don't deliver on the benefit of the doubt rule, then who does?
Mm-hmm.
Right? Where's the checks and balances, right? So I think that at the end of the day, I'm hoping, right, that the court, the Supreme Court, the justices look at this and they realize that there is an issue. And I think that the counsel for the veterans actually did a really great job in opening comments, talking about it and really describing Congress's intent with establishing the U.S. Court of Veterans Appeals and the reason why, and then later coming in and doubling down on they really need to review all the nooks and crannies and corners of the claim to ensure that everybody else either got it right or that they screwed up somewhere. Like this is the final stop, which is why it's so far down the line. And I think some confusion, Clay, for folks as they're hearing about this is the argument for the VA to do something different? Will it change what the VA does? Or is it just focused on the U.S. Court of Appeals for veterans claims and what they are supposed to do? What are your thoughts on that?
I think we will see. Okay, so at the VSR level, they don't care. Okay, the regional office does not care. Once you go to the Board of Appeals, not necessarily the higher court, if you will, at the Board of Appeals, that's where we will see this most likely. I'm not a lawyer. I cannot do legal jujitsu, but they will definitely take into account if someone's implying that the regional office is really reading Bufkin v. McDonough and they're going to change how they operate based on the Supreme Court decision. I don't think that's the case, especially on a rater level at all. But whenever you do take it to the Board of Appeals, in my opinion, that's where we will probably see the most. It's not a change. That's the weird part, right? The best argument was it's not a change. Just do your job.
Right.
That's essentially the opening arguments. And she did a really, really great job with citing code that the VA is already supposed to follow when it comes to the benefit of the doubt. I do want to circle back to the conversation about the 6-month thing. Does this person have PTSD? Probably. And, I don't know what that situation is, but they probably do. The question is it related to military service? And this is not a clean cut. It's not a clean cut slice of cake there. So I'm super interested to see what actually comes out of this. Do I think this decision, the majority of veterans will be affected? Not at all. Okay, not at all.
Right.
I think those, you had said something in the beginning. Millions of claims, 10% of a million claims is 100,000, right? I mean that's a lot of veterans claims there. So we're talking tens of thousands. Those who take it to the Board of Appeals, that's those that will see.
Right.
Not necessarily a change, but maybe more favorable attitude going into the Board of Appeal process. But like for me, the average viewer who's not dealing with the Board of Appeals, I don't think so at all. Now I could be totally wrong, right? Because the Supreme Court could not just agree with Bufkin's side, but they could alter code. They could make it less ambiguous, right? Gaps in policy. We've been talking about gaps in policies for the last few weeks. They could change some things, and that could trickle down, maybe.
Right.
But I doubt lower than the Board of Veteran Appeals.
Right. And the hard thing is how do you measure it, right? It's not like it's grains of sand, right? That they all, it's not, you're not weighing equal weights of things, and it's not this easy, balance to come up with. And that's why they made it the verbiage in there that basically that if it's close, to equal. And I think that when it's close to equal, they have been ruling against the veteran in some cases. Now, back to Bufkin, right? So the story is that he joined the military. His wife became very depressed and whatever other mental health issues were going on from whatever caused that. And she basically had said, look, I'm going to commit suicide if you don't get out of the military because this is causing me just chaos, right? And who knows why, right? Maybe she lost her. We can come up with 1,000 things. Her dad was in the military and he got killed when he went overseas. She's worried this is going to happen to the love of her life, that he's going to get sent overseas and now he's going to die, right? And something happened. And so now here we are. Now, to say that it's, that's a traumatic situation to deal with every single day, going home and getting texts and phone calls. And I'm sure that if there's a mental health issue that's not being treated, that is just a barrage of stress coming at you as an individual. How he deals with that or dealt with that, I don't know. And so now the question is, okay, fine. Is it service? Is there a mental health condition that developed? If he got diagnosed for one, then yes, there is. Did it happen during your time in service? Yes, it did. And you could really say, did it happen because of your time in service? Yes, it did. Because if I wasn't here, she wouldn't be doing that, which caused me this. So I think that that there's a good potential and well, that's hard to say since you went through probably, your first claim, your higher level, your supplemental, your Board of Veterans Appeals, and your U.S. Court of Veterans Appeals. It's hard to say that you have a good shot at getting your a claim, but maybe. Well, typically the VA would just shift gears a little bit. If you filed for PTSD, it's a mental health claim, and they may not grant you, quote unquote, a PTSD type of a granted service connection. They may say, depression, anxiety, and call that your mental health claim and give you 30% and move on. So I don't know, but I mean, that's kind of I think the angle of, for those that don't know the story of that Air Force guy, but that's basically it in a nutshell. As far as the Supreme Court is concerned on this, I think that we will see some cascading effects, like you said, Clay, with regard to, even if the U.S. Supreme Court does not tell the Board of Veterans Appeals to do anything or change anything with regard to how they're supposed to function, just by the nature of the U.S. Court of Veterans Appeals being more, we'll call it that they're going to be more liberal, we'll just say, with that ruling, or look into it and really make sure that they're understanding it. No judge out there wants to be overturned by some other judge. They want to be, I got it right because I'm that damn good. They don't like it when their stuff gets overturned. I could just imagine, right? So they're going to want to make sure they get it right. And if it's close, they're probably going to be more apt to going, okay, well, look, the benefit of the doubt, and, we got to take that into consideration. And this is all blown around everywhere. I mean, they believe me, all these judges know what's going on for sure. All the attorneys know what's going on, and nobody wants to have their claim overturned. Then I kind of take that almost to maybe not the VSR level, right? Because I mean, at the end of the day, they're just clocking in and taking off, right? So texting their friend what they're going to do after work. But from the leadership level at the VA, I would think that they're not that excited when the BVA comes back and remands a decision, or the BVA overturns a decision and makes them undo what they did. One, it's a waste of time for you to get it wrong the first time, then to come back and to clean it up, right? You're working twice as hard, so you're not efficient. So from a leadership perspective, I would be ripping my hair out if I get remands and decisions overturned, because that means that I am less productive as an organization. I need to fix that and have way less of those. So I would be focusing on trying to get it right. And if it comes down to the benefit of the doubt aspect, I'd really be having some conversations on that from a leadership perspective. If it's, you can lead a horse to water, Clay, right? You can't make them drink. So unless there's some sort of consequence, but it's the government and their GS workers. So what's your consequence? An extra day off, paid, stay at home. I mean, you're a GS worker, aren't you, Clay?
Yes, I'm.
Yeah. Okay. So we all know. I mean, here we are filming this. Look at you. So, okay, fine. Clay took the day off, but here we are. So, one more thing that I want to kick it back to you, Clay. The idea, I think, here is that we will see the cascading effects. I think it could trickle into the VA. I think that is going to start happening now already. Just knowing that this case had enough merit to be heard. Just being heard means that the court, here's the funny thing, the court would not take it if the majority of what was being offered to them was like, yeah, no, this is just blowing smoke. They would say no. And if it was overwhelming, they would say, yes, we're going to look at it. And if it was in the middle, if it was in equipoise, they would probably take it. So that means that if it's equal, they should probably just rule in favor of the veterans in which they're seeing and fix the problem. So the VA world, Clay, is a world like none other. It's filled with nuance, and it's got a low threshold of that equipoise thing. Here's my final thought, and I want your thoughts.
Mm-hmm.
How about all those people that have filed claims over their time? I have no medical evidence in service. I didn't really know how to develop or provide lay evidence. I didn't document it in service. I filed a claim. I was denied. They told me to kick rocks. I did. Should I be dusting off my claim and work on some lay evidence?
Yeah, so I see a major player here. How do I say this without sounding like a douchebag? Okay. You know how when veterans are skeptic of speaking with an attorney, not necessarily because the back pay aspect of that, but a lot of attorneys kick it to the board, or there's a stigma where they kick it to the board because that increases time, which increases back pay, which increases, business funds. That's the idea. That's probably the number one skepticism of using a VA accredited attorney. And so we have the attorney side of the house, and then we have the veteran side of the house. Do I think that if a veteran fully believes that they had a true at least as likely, meaning 50-50, and the at least as likely is a nexus statement, right? I'm just saying that for a 50-50. If the veteran has enough evidence for the benefit of the doubt, should they relook at it? I think that answer is always yes. Okay. I think the answer is 100% yes every single time. But then it's like, all right, you're going to go to the Board of Veteran Appeals. That's really when I start considering a lawyer, personally. But now you have lawyers. So that's one. And I agree with that. Do I also think this decision could influence the business model of accredited attorneys and just kick it straight to the board even more so, because now the benefit of the doubt will be enforced. And so it is, you could argue it is more than likely, or I'm sorry, you can argue that it is likely for that attorney to win the case if the veteran has evidence. Just enough evidence, right? They kick it to the board because it's going to do a HLR, denied times 2, right? You do a supplemental claim, and that evidence is not really, it's kind of very close, denied. That's going to happen, so you're going to be forced to kick it to the board, which is going to be good for business on the attorney side of the house. I think the board's going to be a little busier. I think veterans are going to start looking at their claims, and I don't know if it will be a burden on 7-year wait times or 9-year wait times for the Board of Veteran Appeals, which is totally a thing. So I don't know if it's good or if it's bad, right? I'm kind of in this
Good point.
I see attorneys taking advantage of it and just jumping ship to Board of Veteran Appeals because it's easier.
Right.
The law is in their favor. The RO does not operate on the same standards as the Board of Veteran Appeals. Okay, there's a clear line between those. That's my initial thoughts for that. I don't think it's a bad thing at first. However, I think it could easily be taken advantage of from a business perspective. But then again, assuming veterans are being service connected, that's also good. So I'm right.
Yeah. Well, and look, if the board gets up to a 7-9 year wait time because they've screwed it up so many times, well, hopefully they would bump up the board numbers and get that approval if we're loud, right? If the veteran community actually raises our voices and says something, that's the whole, loud mouths get fed. So, I think that this is an opportunity for people that felt as though they were very close and they got denied kind of frivolously. I can't say the word. It might be an opportunity for them to get another claim in. And look, just to speak in the way we speak, Clay, it's about getting the right rating for you. And if the right rating for you is that 30% for migraines that you should have had, but you don't, your evidence was very close. You didn't quite, it wasn't solid. Well, you might want to dust it off and see if you can, work on a little more lay evidence. And we've talked about it before, Clay. I do believe that lay evidence is definitely more favorable in the world of,
Mhm.
you know, the judges than the BSRs. I think that they actually do give it more weight in the Board of Veterans Appeals or at the U.S. Supreme Court of Veterans Appeals. And again, for those watching, the Supreme Court that's viewing the benefit of the doubt rule is really trying to figure out what the responsibilities are for the U.S. Court of Veterans Appeals.
Yeah.
That's what they're looking at. They're not looking at what should BVA do, what should the VA do, what should you do, what should your C&P examiner do. No, they're really focused in at the U.S. Court of Veterans Appeals. Now, again, I'm going to say it. I think that there will be, even if not directed to do anything at any other of the lower levels, I think by default, knowing what the end result is, I think that we will see some internal changes happening subconsciously, even, just kind of going, I gotta look at this a little more objectively. That's another reason why you should make sure that you spend the time up front to really develop your claim and get all of your evidence in a row, and don't shortchange yourself or your evidence. How can you do that? Everybody gets antsy, Clay. Once they decide to file a claim, I mean, they would have filed it yesterday if they could.
Mhm.
And so they get so amped up on getting ready to file that claim that I don't know why, but it's car dealerships would love these people, right?
Yeah.
Come on in, we got you taken care of. Don't even worry about it. What do you want your payment to be? Let's do this.
Yeah.
So, um, file an intent to file and give yourself ample time to develop. I think it's a good transition, Clay, to talk about what
Mhm.
people can do to avoid even being in a situation where this stuff would even take effect or be impactful, right? What are your thoughts?
Yeah, so I'll say one thing. There are many nonprofits. I've met and interviewed one of them who are lawyers who specifically pro bono for free represent veterans at the U.S. Court, not the board, okay,
Wow,
the higher court. And so
for
food for
free.
thought. I forgot the name of it. If you want it, comment below. I'll make sure I'll dig that video up, get that link, and shoot it to you as a response. But yes, this is my favorite subject. Every time I do a video, if I can talk about evidence, I do. This is the most important thing veterans need to know. Uh, if you don't want to go to the U.S. Supreme Court, right? I bet Buffkin and the other veteran really don't want to be in the situation that they're in right now. Okay, prior to that, they didn't want to be at the lower court, if you will. Prior to that, they didn't want to be at the Board of Veteran Appeals, right? Assuming they did supplementals and HLRs, they probably didn't want to do that either. And how do you avoid that? It's evidence, Jason. Um, Everyone knows what the fully developed claim is, which is essentially you letting the VA know there's nothing else to submit. That is the goal, right? There's the stigma on fully developed claims having the evidence from service, the current diagnosis, and the nexus, which would be really good. It doesn't necessarily require those three. The fully developed claim is just you as a veteran letting the VA know I have nothing else to submit. With that said, I like to talk about evidence-based claims. I think veterans at a bare minimum should be submitting evidence from service with the current diagnosis, submit that claim. If you can get a DBQ and a next letter from your provider, and for initial claims, I would most likely never recommend paying for that out of pocket, especially for initial claims. If you can get one, go for it. If not, not a big deal. Okay. But submitting evidence is how you avoid any appeal. And even if the VA does not get it right, because that happens, I'm not going to say it's not often because it does happen a good bit of the time, just not the majority of the time. Okay. Rarely have I ever seen the VA concede to evidence in service, the VA concede to a current diagnosis, and that claim is denied. Okay, rarely have I seen that happen. I have seen it happen, and that's when you go into supplemental appeals specifically, maybe a higher level review, but evidence is the way to go. And I want to say one more thing, Jason, and I'm going to kick it back to you. People get wrapped around the axle on the in-service event a lot. That is the most difficult, right? If you have missing cartilage from your knee, you go get an X-ray. The diagnosis is easy, okay? If you and to be blunt about it, if you don't have a diagnosis, you have no claim anyways. No diagnosis, no claim, doesn't matter. And so the difficult piece for most veterans is evidence from service. Who the heck went to sick call or their battalion aid station or medical, whatever that looked like for them, right? Jason and I were both in the Marine Corps, almost 20 years apart, okay? And although there was a huge time gap, I would bet my life there was a stigma in Jason's peer group of not going to medical because you don't want to be that guy. And it was the same for me. Okay. And that is across all services, especially your combat arms MOSs, like infantry, your artillery, even motor T, right? Any ground MOS will definitely have that. And so who has medical evidence? And that's the hard piece. Medical evidence is really good. However, there's also evidence other than medical, and a ton of veterans fall into that piece, right? Did I go see my doc, my corpsman medical for my migraines? No, I did not. Did I have migraines during service? Yes, I did. How am I going to not necessarily prove that, but how am I going to show enough evidence to get at that mark, right? And that's when things get difficult. And that's really, in my opinion, if you don't have a lack of medical evidence from service, veterans should, I would argue this till the day I die. If you don't have medical evidence, veterans should 100% submit any and all evidence other than medical with their claim. Okay. I don't care who tells you differently. That's my advice. Go for it. Especially if there's a lack of medical evidence from service. I'll talk all day about that, Jason. I'm going to kick it to you and just shut
up. It's so important, evidence. And again, with the idea of really providing enough to get over that threshold of equipoise, right? That's the goal. And what I think may be happening out there in, the virtual world is there's so much focus on the benefit of the doubt, at least as likely as not, blah, blah, blah. So, okay, well, all I need to do is go to here. There you go. Boom, submit. Then when you get an unfavorable decision, you're pissed off and you don't move forward and you move on with life. So instead of us focusing on the let's just get at least as likely as not and we'll get it through the door, let's get to the more than likely, right? Mm-hmm. Let's get to the more than likely. Let's provide that. Let's make it easy for the VA to go, oh yeah, I'm a fan of looking at this like telling a story, okay? Because most of us, like you said, don't have hard concrete evidence unless it's for like an injury that you incurred while you were in because you had no choice but to go get treatment for your broken leg or whatever it is, right? So you need to build a story around it and everything kind of needs to tie into each other. Some of the common types of evidence, obviously, are your service treatment records, your medical records. Inside there, your self-attesting forms where you are self-attesting to essentially symptoms because you're not diagnosed. You're just, have you now or have you ever experienced any of these? And it's got 50 things and you're checking yes, no, yes, no's. So it's really important to go through your service treatment records. In addition, your military records of just other things that were going on, there might be pieces in there that help to corroborate a story, right? If you have a little bit over here and a little bit over here that tie together to explain this, it helps. That time that you rolled the Humvee over, right? And the wrecker had to come and fix it and you were in it, but you said you were okay, right? That's proof you were in a rollover. And then the mindset of I can't go to medical and I just popped a bunch of Motrin and wrapped an ace bandage around it and called it a day. It's you telling the story. It's explaining with pieces of fact that you could prove outside of yourself, right? Supporting statements, that's your buddy statements. Buddy statements don't just have to be, Clay, from somebody you served with. It could be from a family member. It could be from a friend. It could be from clergy. It could be from anybody that knew you when you were in specifically. I personally love they knew me before I was in. They knew me when I was in. They knew me when I was out. So they can tell the story of you never used to sit at the table with a bunch of, Tums and Motrin as you were eating, right? That never was a thing until you got back, right? Lay evidence, right? That's kind of all encompassing. There's a lot of stuff that can be used under that. Medical opinions, employment records, if you're trying to prove the severity of your condition, right? Evidence is not just pointing at, I have a condition. It's also the impacts of your condition, right? Remember, there's two goals: get service connected at the appropriate rating. Those are two things that you have to consciously think about as you're providing evidence. You forget about one, you're going to not have a good result. Some uncommon things that people don't think about for evidence, Clay: my MOS, right?
Mm-hmm.
Let me prove my MOS because my MOS put me in more of a impactful situation, right? I was mortars. I was infantry. I had to carry a pack with all my stuff, and we had to walk for 25 miles all the time. And my back hurts. Well, your MOS helps to tell that story, right? Because of the nature of it. If you did any sort of, we had like competitions against other 81 millimeter mortars, so other mortar platoons, and we would do a competition, and so we won. So we got Navy Achievement Medal for winning, right? And then but inside there it tells the story of why you won this, why you got this medal, right? And it's talking about the vigorous hike and the all the weight you had to carry and what kind of time frame you did it in. And this is all things that tell the story. How about a letter that you wrote to home to your mother who still has it, right? Or who gave it back to you as a keepsake, that you wrote about how you twisted your ankle, or you did this, or you did that, or your migraines are killing you, or to a loved one. Maybe you have a letter like that. Maybe you forgot that you even wrote that. You'd be surprised what you read in things that you wrote 20 something years ago. But getting that is evidence. Pictures are evidence. All of these things count as evidence. The more you supply, the more that the scales start to tip in your favor, right? Tell the story with your evidence as well is a big thing for me, Clay. Back to you.
I like the storytelling aspect of that. That's an absolute, solid lens just to look at your life when it comes to evidence from service. Now, obviously, if you have medical evidence, right? I am. When veterans reach out to me for help and they say, "Hey, blah 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 blah," I comment back saying, "What's your evidence from service?" If they say none, then I understand immediately, without even knowing their situation, they're going to have a rough time. I understand why they're reaching out. When I have veterans that reach out to me and they do say they have medical evidence, I'm just like, okay, we'll go get diagnosed and submit the claim. Like, if you have medical evidence, you are, I don't want to say privileged because that's not the right word, but you're
Fortunate.
You're almost fighting a winning battle because you have medical evidence from service. It's those veterans who don't. And I don't think I've showed you this, Jason. This might not be my proudest moment, but I have a giant 0341 tattoo here in my arm.
Solid.
Yeah.
Solid.
Have you showed you that before? I don't know.
No. And I'm kind of glad you didn't.
Yeah, well,
I'm glad you saved it till now. I appreciate it. Thanks for the peek in. I almost got just a gigantic Eagle Globe and Anchor, but then I decided not to.
Yeah, I have not done that. I probably will never do that. But I
Well,
do
now
have.
I'm out, so now I won't. Right?
Well, yeah, you never know. One drunk night can lead you to a tattoo
That's
parlor.
true.
I've been there
That's
many a
true.
time.
That's
Um,
yes, agreed. I do have some dumb ones. I do have that.
I do want to talk about evidence. Now, this is going to be super niche, and I'm not trying to sound super cool or anything, but I see a lot of comments where veterans say, "Hey, I was in a classified area, XYZ. I don't have
Mhm.
access to my medical records."
Right.
There's a few things here. There's a whole process the VA has direct to the DoD that looks at those records specifically for conflicts like that. How do I know? Because that's
Right.
how most of my stuff was service connected from Syria, and we'll kind of leave it at that, right? And so, even if that is you, you still fall into that. Now, I want to talk about Vietnam veterans specifically because when it comes to medical evidence and just when it comes to records in general,
Right.
they're basically disintegrated, right? They're gone. That sucks. Jason and I, we've done videos. I'm gonna post it below in the comment section on how to request your service treatment records. But every single time a veteran asks, "How do I get my records?" it's never a good answer. It's definitely not an overnight process, and there's a high chance that they are gone. And that is never. I even hate talking about it because it's such a
It
it's bad. It's a black eye in the DoD. If any court's going to start rolling on anything, let's look at the DoD and medical records. Anyways, that was an offshoot. Jason, I just wanted to answer the classified area because I see
yeah,
that comment a lot, and the
that's
VA
great.
has a process. It's called something. I just forgot what it's called. But yeah, I think. Do you have anything to add to that?
Yeah, I'm just gonna. When you said that disintegrated, it really made me think of the fire in
Yes.
1973, right? So on July 12th, 1973, there was a fire at the National Personnel Records Center, NPRC, in St. Louis, and that fire destroyed about 16 to 18 million official military personnel files. About 80% of them were Army between 1912 and 1960, and 75% of the records for the Air Force veterans discharged between 47 and 64. So, all for sure your Korean War vets, your a lot of World War II. And it's just such a sad situation. And this is where we really came into the point of, do you have a picture? Do you have a letter? Do you have
Yeah.
anything that can show? You know what I mean? And we were piecing things together. You could get some pieces of records, like a burnt half of a page, just anything to help. It was a sad situation. Some custodian there smoking when you were allowed to smoke indoors everywhere. Stubbed down a cigarette on a shelf, and then up it went. How'd you like to be that guy?
Yeah.
Oh. Anyway, yeah, party. So,
Yeah.
evidence,
On,
good
on
things.
on that note, there is legislation. I forgot the name of that bill that that talks specifically to those veterans, and that bill would make lay evidence like a statement. Basically, everything you just said. It would make lay evidence on a higher tier, right? And so instead of
Right.
being lay evidence, it would be evidence for those veterans specifically. I haven't looked that up in a while,
Yeah.
but I'm sure it's just
There is the Fred Hamilton Veterans Lost Records Act. That was in 2023, which would authorize VA to grant disability claims using previous medical disability exams, credible buddy statements, or statement from impacted veterans whose records were lost or destroyed through no fault of their own. There's been several versions of that type of stuff that have gone around. The VA does have a web page specific to all of that information as well. So if you just Google search, record VA veteran records fire VA claim, you should be able to land on that page, and you can always shoot off some comments as well, and we'll try to figure it out.
Yeah. The last topic I want to kind of rope back into the appeals, Jason, and bringing
Uh-huh.
evidence with appeals. I had mentioned this earlier, but and I'm going to use migraines as the example because I think migraines is the most common HLR that is overturned. I have no facts for that. It's just people who I've talked to. Migraine seems to be the number one. Veterans will submit evidence. I'm talking hard medical evidence from service, from the VA. They'll be service connected and commonly awarded 0% for migraines, right? Or 50% for mental health when it should have been 30 or it should have been 70 in the mental health case. When veterans submit evidence, that's when a higher level review comes into play. Now, HLRs, higher level review, you can only do that within 1 year of receiving that decision. And generally speaking, I see HLRs being successful for claims that are service connected, but were rated lower. Can an HLR work for service connection? It absolutely can. It's just very uncommon because you'll see a duty to assist error come out versus a full-on overturn of service connection. And the last thing I'll say about duty to assist errors, there's been a huge increase in duty to assist errors recently, and I think there's many factors involved with a duty to assist error is a good way to say the VA messed up. Okay, the VA process messed up. That's essentially what DTA error means. I think the two most common factors are one, there's a lot of new VSRs that are being pushed through training pipelines to rate claims. Two, VSRs are rated professionally, right? But bonuses, time off awards, step increases, wherever that looks like on the federal employee side, it's a production quota. So, for instance, let's say Jason and I both have 10 claims, okay? I get through my 10 because I'm trying to meet my production quota and get that step increase. 4 of them are correct. 6 of them are going to come back with duty to assist errors in about a year from now. Jason has 10 claims, and he does his due diligence on 4 of them. And they are rock solid. They are complete. They are correct. Who gets graded higher, right? Me, who did 10, although it was a half-assed, if you will, or Jason, who did 4, right? That's the production quota. And so the VA's tailoring to production quotas, which leads my third and final factor of duty to assist errors. So training requirements, production quota, excuse me. And the third one is the PACT Act, right? Because we've had the VA has had millions and millions and many claims. 1.2 or 1.3 have been approved as of since January 23. That's not including the ones who haven't been approved and the ones who've been denied. Okay, that's a lot of claims, and so now you have these training requirements, the production quota, and an influx of claims. And that's why we see duty to assist errors. And I think it bears credence to why veterans need to submit evidence with their claim. Do you have any thoughts on that, or do you want to roll into supplemental?
Let's roll.
Yeah. When it comes to evidence and supplemental appeals, Jason, how would you approach a veteran submitting new evidence for a supplemental appeal?
Right. Well, read your decision letter first,
Yeah.
because that's going to give you some insight on what you are putting your supplemental in for. Right? Was I denied service connection, or was I denied a rating that I think I should have had? Right. So depending on what you need to prove, or it could be both. Right. I mean, you might not even have a rating because they just denied your service connection. Right. So depending on what you need, you're going to need to double down really on the evidence that you've already submitted. Typically, this is going to be, in my opinion, Clay, somebody who I just want to get my claim in as fast as I can.
Yeah.
I had access. I had the ability to get all of this evidence. I just chose not to. I supplied what I think I needed, and now here we are. And now I'm mad that the VA didn't give me what I wanted. So now you got to take a knee you have a year. So you have a year from that decision, that unfavorable decision, to get your act together. Now, if you need to double down on the service connection piece, well, there's two ways, right? You can dig through your medical records if you didn't do it already, right? Because obviously you didn't supply enough. So if you did not have access to your service treatment records, you're going to want to order them. How do you remember this form? Think of a circle as 360. 180 is half. So you're looking backwards, right? Straight behind you. 180. SF 180, standard form 180. That's the form you can order your records. So you'll never forget it. So order your records, get those records, go through them. See if you mentioned anything regarding the condition in which you filed for. It could be the condition itself, migraines. It could have been you checked a box that said headaches, right? You could have had an entry somewhere in some sort of a medical exam. You could have written something down somewhere and it got signed. Whatever you see that talks about headaches, head pain, blurry vision, seeing stars, blurry spots, you could have some ocular migraines going on. Anything that you see in your file about any of that stuff, pull it out. I don't care if it's one little word. The fact that that one little word existed in your time in service is worth its weight in gold. Well, it's worth more than that because it doesn't weigh very much, Clay. All right. So get anything you can find there. Then you're going to want to take that to your doctor. You're going to want to have that conversation with the doctor. And this is what you should have done up front. That's why it's a weird conversation to have, because you didn't do it up front. That's why you're here today. So work with your doctor to get them to write you a nexus letter, right? Tying your condition to your time in service. In their opinion, it is more than likely that your condition manifested during your time in service, as evidenced by your complaints of migraines, headaches, whatever you showed them from your medical record as rationale, right? Hopefully they'll do that for you. What I like to say, especially with a private doctor, non-VA doctor, is, hey doc, I'm glad to see you today, right? Here for the migraines, blah, blah, blah. Hey, I'm filing a claim with the VA so I can get reimbursed for my medical expenses. I need to submit a little letter that just explains that my migraines were, had manifested during my time in service. I brought in some papers that show, that it did. Could you put it on a little letterhead for me? In fact, here's a sample of something that would work. Thank you. I appreciate you. And I'll be back to spend more money with you.
Yeah.
So that's kind of how that works, right? So you want to double down on all the aspects of that. Get your buddy statements, family, friends, whatever. Then when you're looking at your service connection piece, you're wrapping all that together and getting that piece taken care of. You're looking at your rating aspect. Clay, we both know the value is in the knowledge of knowing what the VA is going to rate you against, right? You can close your eyes and throw darts at a dartboard, or you can go look at the dartboard, right? They have it for you. It's the CFR and it's the schedule of ratings within the CFR, Code of Federal Regulations, has all of the codes in there. It's a little bit cumbersome. I get it. If you can't find it that way, Google search your condition, VA rating schedule. If you Google search those words, up will pop 5, 6, 10 different attorney sites that have pulled that information onto their website. And they'll explain to you, if you meet this criteria, you're at 50%. If you meet this criteria, you're at 30%. If you meet this criteria, you're at 10%. Read it. If it's medical jargon and you're not sure exactly what it is saying, then Google search that word and it'll give you the human word for that medical word, right? So like, for example, dysphagia means difficulty swallowing. Why don't you just say difficulty swallowing so everybody understands? Because they like to feel like they're better. It's fine. Just do what you got to do to figure it out. Once you get all that stuff, go to your doctor, have the conversation with them about embedding that information into your treatment records. And oh, by the way, if you didn't have them write your nexus letter yet, have them include that on your nexus letter. And oh, by the way, the veteran is experiencing these signs, symptoms, and time frames, or whatever they say, right? And they spell it all out, and it can be verbatim. Nobody says you can't look at that schedule of ratings, and you can't tell your doctor that you have that, and you can't have your doctor put that on a piece of paper acknowledging that you have that. That's stupid. So don't feel weird having them put it exactly to make it easy for a VSR who's texting their friend wanting to. Granted, look, if you're a VSR watching, not all VSRs are crazy, right? We all know there's the crazy people, and then there's the people that actually do their job. There's more of you, in my opinion, that do a great job than those that do the bad one. The bad ones, however, get highlighted, and that's what we talk about. So sorry about that, because there's a lot of good ones. You, Clay.
Yeah, the last thing I'll say, and then I'll kick it to you for your infamous outro.
Right.
When it comes to appeal specifically, the most difficult aspect that I see is that when a veteran has been diagnosed, but the CMP examiner's rationale was not service connected, right? And they'll say whatever. However, they won't say what the diagnosis is caused by, right? And so when you're arguing with a medical professional, one's difficult, right? We can't do that alone. You're going to have a medical professional in your corner. And in my opinion, that's when a lawyer also really comes into play when you're arguing rationale. A diagnosis implies there's some kind of cause, right? You have an undiagnosed illness, which is still a diagnosis. It's just undiagnosed because there's no cause. And I can't stand how CMP examiners will give a diagnosis and say, nope, not related to service. Okay, well, what is it related to then?
Right.
Tell me what it is related to, and let's go through that. You as a veteran, do not say that at your CMP exam. That's not going to go well for you every time, okay? But in that instance, that's when appeals really get difficult, is when you're arguing with a medical professional who gave a, bottom dollar rationale and just said not service connected without evidence, without anything saying what it is connected to. And so food for thought. Some appeals are easy. Some appeals very, very difficult. You have to figure out which one you're in. That's all I got, Jason.
Outstanding. I agree. And so, hey, with that, if you hung on to the end, thank you so much for watching. It has been these are sometimes long shows, and we really appreciate you hanging on to the end. We appreciate all of your support to the channel. Thank you guys so much for watching. We appreciate every single one of you. Have a great one. And remember, if we don't take care of each other, something went wrong.